Hi. So whenever you file a case in the court which is called a suit, the first, an intelligent defendant or his counsel may file an application called the rejection of plaint. That is to say, he wanted the court to reject the plaint in the beginning itself. That is, without conducting the trial, without leading the evidence, without even informing his reply to the court. He wanted the court, that is, the defendant wanted the court to reject the plaint. That application is called application for rejection of plaint under Order VII Rule 11 of the procedure code, civil procedure code. Now broadly, the plaint is rejected. That is, the case filed by the plaintiff is rejected. Like if you don't pay sufficient court fee, or if you show a wrong valuation, or if you don't have a case at all. That is what he is going to argue. The defendant against whom you filed a case will come to court and say there is no case at all. In such instances also, plaint will be rejected. And if it is expired or barred by law, then also plaint will be rejected. So these are the few conditions which attract the rejection of plaint, and because nobody should suffer a vexatious litigation, and such kind of vexatious litigation should be nipped in the bud, should be killed in the beginning stages itself, is the law, and in the interest of the justice, that is fine. If it is really a vexatious litigation, if it is really a case that is filed just to harass the other side, then court must come forward and assist the other side, that is the defendant, and throw the case out of the court, so that it will save the court's time also and the defendant suffering also. Now the point what I wanted to share with you here is, at what conditions court cannot throw the case out of the court at the threshold stage. Now, in the process of pleading, in the process of informing the court about your entire case, you may inform some parts which are expired. That is to say, some cause of action which is expired and some cause of action which is alive. Some parts may be barred by law, some parts may not be barred by law. It can be a mix of both, or it may be court fee or valuation or anything. So Supreme Court said that the plaint has to be rejected as a whole, or it must not be rejected. That is to say, if a part cause of action or a part of the plaint, some part of the plaint is alive, or some part of the plaint can be decreed, or some part of the plaint is not barred by law, if there is a triable issue to that part, and some part is expired, some part is barred, court must invariably dismiss that application filed by the defendant to reject the plaint and continue with the suit. And the logic I am going to explain. Because the defendant can take the defense about the expired part in the due course of the trial. At least the part which has a valid cause of action, which is not barred by law, which can be tried, that has to be that will be allowed by the court, that will be decreed by the court. When court can pass a part decree, when court can allow one prayer and court can reject another prayer, when court can go ahead against one property and reject another property, what is the need to reject the plaint? It can go ahead. Because court anyhow the expired portion, the invalid cause of action, will be anyhow thrown out in due course of the trial. But the valid portion, the valid cause of action, the part which is not barred by the law, that should not suffer. Therefore, rejection of the plaint, the principle here is that the rejection of the plaint must be done on a whole or must not be done. Suppose if there are 10 defendants, some defendants don't have a cause of action and some defendants have a cause of action. In that instance also plaint must not be rejected. So the principle you must always remember is that the plaint can be rejected as a whole, but not in parts. Hope I am clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.